that is yesterday's matter. My lord, I need some instruction from my client. My lord, can it be fixed on 23rd of this month?
On request made by Mr. S. Thakur for the applicant. This on 31st.
23rd.
23rd.
My lord.
23rd.
Much obliged.
Yeah, please, your lordship. The concern of others, big to item number 1.
One.
Lordship.
Okay.
Lordship, I've already supplied the adjournment slip. Lordship. You have taken notes.
Lordship, may I pray, Lordship, next week any day subject to convenience of this honorable court, Lordship. It's a
Okay,
little
heard
bit
K.
arduous.
Majumdar and the counsel for the applicant. On request made on behalf of H. Gupta and the CGC. This is the matter. When do you want? After a week?
Lordship, next week any day subject to convenience, Lordship.
Right, because that's it. 21st.
21st, March obliged, Lordship.
My lord, this may be matter may be listed on 20th, my lord. Matter released to settlement of fishery, my lord. Writ appeal.
Actually, I'd like to mention item number 10, Lordship, 10 to 13 and supplemented 13, Lordship. In this
10?
10 to 13 and supplemented 13, similar manner, tag matter, Lordship. And for the respondent, I just filed the affidavit, Lordship. Huh?
Already filed.
Just given the copy.
I'm protecting madam.
So what do you want?
Any date, Lordship, adjournment for say.
You are Mr.
P. Sharma.
Okay, and request made by P. Sharma, then the counsel for the respondent. When do you want?
Any date after 2 weeks, Lordship.
Please, the matter.
Not after 2 weeks will do, Lordship.
After 2 weeks.
10 to 30.
10 to 13. And 30 is also there.
30.
And supplemental is 30 also.
Same order.
May I please, Your Lordship? Lordship, we have filed an appeal tomorrow, yesterday, Lordship. Maybe taken up on tomorrow, Lordship.
Why tomorrow?
There is some urgency, Lordship. Maybe taken up tomorrow.
May I please? Item number 18 and 19. This Mr. Supposed to agree by Lordship, our board Lordship, he is in bereavement, Lordship. After
No, I am for the respondent, my lord. A matter of 18, my lord. Maybe may I pray for a fixed date, my lord?
Okay.
I am for the 19.
It is submitted to Mr. R. Barbujari, Leonard Council. Appealing for the appellant is in bereavement. Accordingly, Mr. Metram, after what?
After 3 weeks, Lordship.
3 weeks. You want a date fix?
My lord.
Give a date after 3 weeks.
Yeah,
My lord.
12th of December.
After they finish the mention.
May please, your lordship.
Yes.
Lordship, regard to item number 29, your lordship. But lordship, my only anxiety, lordship, will like to fix a date or should I approach the registry, your lordship?
You can take up. Okay, list this case before any other bench without one of us.
Much obliged.
Item 3 also.
Item of daily list, admission.
May it please, my lord. I apologize, but I'm praying for an adjournment today, my lord. Because Mr. S. Bodhakur, who is leading us in the matter, his father was hospitalized last evening, your lordship. So,
my lord, any date may be fixed, my lord. I am the read petitioner, private.
When do you want?
this month, any date, my lord.
Okay, on. Yeah.
So, Majumdar, my lord, this issue can be resolved at your end only.
My lord.
In the rules, you say direct recruit. Earlier direction was that they should make a provision for promotion. You have issued an OM. Wherein you say promotion. Now, in view of the provisions of the rules,
this OM cannot stand.
The OM says direct recruitment.
No, OM, there is a promotional exercise.
We try to make it look into a promotion, but it is actually a direct.
Direct recruitment. So if that thing can be resolved, that word direct recruitment in that rule, it can be
My lord,
considered
yes,
as a provision. You do whatever qualifications method, it's yours. But if that two words can be converted, that you can do it.
My lord, in fact,
Examine that.
in fact, my lord, in the rules were under consideration for other sections also. And perhaps something has come up, but it has not been notified in the Gazette, so it has not taken effect. I'll have to take my instructions whether this has been taken care of or not.
Next time,
Otherwise, there is some amendment to the rules.
If,
that the whole matter can be resolved.
Yes,
my lord, if rule is made, my lord, everything will be all.
I will have that instructions.
Request Madam Deogo is about to put in a council for the apple. How much time do you want?
Lordship, 2 weeks.
Thirty.
Much obliged.
My lord had appeared, my lord,
There's an amicus curiae.
amicus curiae, case 61.
This case before any other matter does one of us. Yes, no.
May I please, your lordship? My lord, I'm sorry, I'm appearing through VC as I could not be there physically, my lord. I'm sorry. My lord, your lordship had asked them to file a counter,
That's correct.
which
Yes,
has not come yet.
Lordship, our instruction is still awaited, affidavit is under preparation. Perhaps the stand of the central government would also be very important in this matter because it's a wildlife subject, which is under the central government, your lordship. Though the state does oversee it on the ground level, but it's a central subject. So the stand of the central government would be necessary.
who appears for the central government?
I agree with my friend because it has to be defended by the central government council.
Yes, Google. Oh,
There is already a liberty given to file affidavits. All this.
his name is Gay Google.
For timing, I will consult with the.
File an affidavit.
You have to file an affidavit.
We received some instruction, my lord, we also filed the affidavit, my lord.
Oh,
But one thing is that my central here is select the highest of the act, my lord. Of the, my lord.
that's what,
Yes, my lord.
that's why we require an affidavit from you.
So lordship, I grant 3 weeks time in the meantime, lordship.
Okay. Respondents are allowed 2 weeks time to file the respective counter affidavits.
May I request if your lordship could have it on the 5th or 6th of December, my lord, so that I can be there physically.
2 weeks time will not be,
3 weeks time is required, lordship. We have to obtain instruction after that.
we'll have it on 11th. Is it okay with you?
Obliged, my lord, deeply obliged.
11th.
My lord, the interim order, the last date had, your lordship had indicated that the interim order will be considered after the counter affidavit comes. Your
Yes.
lordship indicate that
That is
in the, deeply obliged, my lord, deeply obliged.
32 of supplementary list admission.
Move to go.
Hmm? Hmm. And accordingly, they will- They can go back. They won't issue.
The single question.
May it please, your lordship. My lord, the basic facts are in a very narrow compass. There was a tender process floated by the APDCL leading to selection of the writ petitioner respondent number 1. And thereafter, the project did not even start. Ultimately, we were compelled to invoke the security. The dispute revolves around this, my lord. If your lordship will first come to the NIT itself, particularly clause 21 at page 76. This has a very fine importance, very subtle importance. Page 76, clause 21. Signing of the project agreements and financial closure. The successful bidder or the SPV formed by the successful bidder, as the case may be, will execute the project agreements upon satisfying the following conditions within 30 days from the date of issue of the LOA. First precondition is signing of the project agreements, PPA. Next, we are concerned with this. Submit the performance security or performance bank guarantee or equivalent in the form of a bank guarantee in accordance with the provisions of the RFS. What I'm laying emphasis on is it is the successful tenderer who is required to submit it. Now, this is in addition to the bank guarantees. This is the agreement that was at page 101. This is the bank guarantee agreement executed by the bank in favor of APDCL. Now, this is the reason I pointed out clause 21 is this is a document submitted. It did not fall from heaven. It was submitted by the writ petitioner respondent number 1. And if your lordship kindly turns to page 103, this is the clause. We are liable to pay the guarantee amount only and only if we receive from you at our address stated below a written claim or demand no later than 1 year from the said expiry date. This is important. Failing which, all your rights under this guarantee shall extinguish and we shall stand completely discharged. This is there is an expiry date of the bank guarantee. However, it can be invoked. However, the agreement says that it can be invoked 1 year from the date of expiry. So, in my humble understanding, the expiry date itself is the date of expiry as given plus 1 year, the effective date of expiry. Now, my lord, in this context, the matter came up before the Honorable Single Judge, and this is what has been held. The facts are narrated. It starts at page 124. The page 125, my lord, the facts are narrated. And what has been the conclusion drawn is in the third paragraph of 126. Law is firmly settled that invocation of irrevocable bank guarantees cannot be injuncted by the court save and except upon fulfillment of at least one of the two grounds. 1, practicing fraud, and 2, irretrievable damage to the parties. Having held that these are the only two situations in which it can be injuncted, now the learned single judge proceeds further. After going through the materials on record, this court is of the prima facie opinion that none of the above conditions are fulfilled in this case. To this extent, my lord, it is in my favor. Now, However, the larger question that confronts the court in this case is as to whether the bank guarantees which have already expired can still be encashed at this point of time without extending the validity period of the same, merely on the basis of an agreement entered into by and between the bank and the employer, wherein the writ petitioner is not even a party. Firstly, my lord, this sentence itself contradicts the first, the settled principle as has been accepted by the learned single judge. The next sentence gets contradicted. And secondly, my lord, the foundation of this sentence is wherein the writ petitioner is not even a party. In a bank guarantee agreement, nowhere the contractor is a party. It is the bank who assures the party concerned, the employer, that in such and such eventualities, we will indemnify you like this. So this, my lord, in my humble understanding, this sentence itself runs counter to the first, what has been, what is the settled law? My lord, I'll place another judgment which perhaps the learned single judge completely overlooked. This is more so since the particular clause in the bank guarantee agreement relied upon by EPDCL apparently runs counter to the terms and conditions reflect in the communication dated 4/1/21, which makes the bank guarantees valid only for a period of 22 months from the date of signing of the PPA. This court is therefore of the prima facie opinion that there is a genuine controversy involved in this case, which would require further consideration by the court. Accordingly, notice is issued, heard on the interim prayer, etc. However, last paragraph, however, having regard to the peculiar facts and circumstances of the case, as an ad interim measure, it is hereby provided that if the bank guarantees furnished by the petitioner have already expired on the dates indicated in the letter dated so and so, and the validity of the same have not been extended, then and that in that event, the same shall not be encashed without the leave of the judge. The learned single judge holds that in these are the two conditions where it can be injuncted. However, the learned single judge injuncts. In my respectful submission, my lord, firstly, my lord, clause 21, one of the foundations to the sentence as I read out, starting from however, is that the writ petitioner is not even a party to the agreement. Nowhere the contractor is a party. It is an agreement. Bank guarantee agreements are always between the bank and the employer. This aspect has been overlooked. Secondly, my lord, one of the judgments of the Supreme Court, and although the proposition as has been laid down by the learned single judge is also there, but there is a further requirement, my lord. If I may place the judgment for 2007 volume 8 SCC 110. This is Himadri Chemicals, my lord. 2007 volume 8 SCC. I think the book list has been given. 2007 8 SCC 110.
You don't have a copy?
Extra copy 9. They would look.
Yes.
2007 volume 8 SCC 110. And I am relying on paragraph 14, particularly two of the parameters that have been laid down by the Supreme Court.
Yes.
Para 14. From the discussions made herein above relating to the principles for grant or refusal to grant of injunction to restrain enforcement of a bank guarantee or a letter of credit, we find that the following principles should be noted in the matter of injunction to restrain the encashment of a bank guarantee or a letter of credit. We are not really concerned with one. Two, the bank giving such guarantee is bound to honor it as per its terms, irrespective of any dispute raised by the customer. Its terms. So it will be governed entirely by the bank guarantee agreement between the bank and the employer. Now, my lord, subpara 4 is also important. Since a bank guarantee or a letter of credit is an independent and separate contract and is absolute in nature, the existence of any dispute between the parties to the contract is not a ground for issuing an order of injunction to restrain enforcement of the bank guarantees or letters of credit. So since it is an independent document and a binding document, nothing can come, any dispute cannot come in the way. Now, my lord, the third submission that I would like to advance on this issue is, your lordship has seen that particular paragraph. If I may take your lordship back to that page 126.
Yes.
That particular paragraph, the first sentence, the learned single judge holds that these are the only two circumstances in which an injunction can be granted. Now, next para. However, the larger question that confronts the court in this case is as to whether the bank guarantees which have already expired can still be encashed at this point of time without extending the validity period of the same, merely on the basis of an agreement entered into by and between the bank and the employer wherein the petitioner is not a party. This is at best a legal point that has been made out. Your lordships are aware, after Cochin International Airport's case, your lordships, in contractual matters, your lordships do not interfere merely on the making out of a legal point. If I may place that judgment, my lord. Cochin International Airport is very clear on this. At best, it is a legal point made out by the petitioner. However, the preconditions are, the learned single judge himself holds that the preconditions are not met. So therefore, my lord, in my respectful submission, and in any case, your lordships are aware, money is always safe with the authorities. If he wins, he will get back the money. If the writ petition is decided in the petitioner's favor, he will get back the money. It will always be safe with the authorities. That Cochin International Airport, I'll just read out the relevant sentence, my lord. Para 7. It is 2000 volume 2 SCC 617. Para 7, the last 3 sentences. I've got it. Towards the bottom of paragraph 7, there is a sentence starting, even when some defect is found. Has my lord. Even when some defect is found in the decision-making process, the court must exercise its discretionary power under Article 226 with great caution, and should exercise it only in furtherance of public interest and not merely on the making out of a legal point. This is what I'm laying emphasis on. So what the learned single judge has held for the purpose of granting an interim order is at best a legal point that has been made up, after having held that the preconditions are not even applicable in this instant case. So therefore, my lord, in my respectful submission, this was certainly not a case for granting of an interim order injuncting the invocation of the bank guarantee, which the clause itself makes it very clear. The agreement between the bank and the employer is very clear that it can be invoked 1 year beyond the expiry period. So therefore, in essence, the effective expiry date is 1 year from the date of expiry as has been fixed. And that is what is the agreed terms. So this will amount to, my lord, interfering with the independent agreement as has been held by the Supreme Court in 2007-8 SCC.
But then leave was granted to you, isn't it? You can engage it with the leave of the court.
Well,
What's the point?
no,
of
it is,
finding
if your lordship peruses the language used by the learned single judge, it is used in the negative sense.
that? No.
If your lordship will kindly come to that last paragraph where interim order is granted. However, first the question is framed. Then at page 126, if your lordship comes back to the sentence starting, however, the learned single judge has already expressed the prima facie opinion in favor of the petitioner. However, the larger question that confronts the court in this case is as to whether the bank guarantees which have already expired can still be encashed at this point of time without extending the validity period of the same, merely on the basis of an agreement entered into by and between the bank and the employer wherein the petitioner is not even a party. This is more so since the particular clause in the bank guarantee agreement relied upon by APDCL apparently runs counter to the terms and conditions reflected in the communication dated 4/1/21, which makes the bank guarantees valid only for a period of 22 months from the date of signing of the PPA. This court is therefore of the prima facie opinion that there is a genuine controversy involved in this case, which would require further consideration by the court. And thereafter, now, if your lordship comes to the last paragraph, however, having regard to the peculiar facts and circumstances of the case, as an interim measure, it is hereby provided that if the bank guarantees furnished by the petitioner have already expired on the dates indicated in the letter dated so and so, and the validity of the same have not been extended, then in that event, the same shall not be encashed without the leave of the court. Now, my lord, having expressed an opinion in favor of the petitioner, this will mean that we cannot, because we have already tried to invoke that. It is in that context that this order has been made.
Yes.
Yes. My lord, before I reply to my learned friends, my lord, contentions, I'd like to make one preliminary submission, my lord. Now, here is a case, my lord, lordship is exercising power of writ appeal. Writ appeal is an appeal in principle only, my lord. It is not like an ordinary appeal where lordship exercises coextensive power. It's an appeal in principle. Now, my lord, what is the wrong in that order? A tentative prima facie view has been taken by the learned single judge in the facts of the case, which learned single judge has not given finality to the views. It is a tentative view of the learned single judge. In the facts of the case, learned single judge considers that an arguable case has been made out. Therefore, court would like to examine the case and to protect the interest of the parties, an interim order has been rendered. Now, merely because another view as suggested by my learned friend is available, that by itself is not confer jurisdiction upon a lordship to invoke the appellate power. That's another view. Maybe there is a possible view, but that will not entitle my learned friend to get away with an order from this honorable court. Otherwise, my lord, the power of the learned single judge to pass an interim order in an appropriate case will be lost forever if my learned friend's contention is to be accepted. Only a tentative prima facie view has been taken by the single judge. In other words, a discretion has been exercised. My lord, it is a well-settled proposition of law that when a discretion is exercised, normally an appeal does not lie against the exercise of discretion, unless the discretion results in a failure of justice or it occasions an abhorrent failure of justice. Only a tentative view. Now, let us come to the merits of the case. Now, my lord, my learned friend is correct that the bank guarantee is an independent contract. There is no dispute about it. And normally, court would be very slow to interfere with any matter arising out of invocation of a bank guarantee. There are two situations has been visualized when court can interfere. One is if there is a fraud, and secondly, if irretrievable damage is caused to either of the party. My lord, if I say clause 4(3) on which they are relying is an outcome of an exercise of fraud, will it be wrong on my part? Why I am saying so? Now, lordship will kindly. In fact, here is a case where we can invoke the exception of fraud. This 4(3) is the result of exercise of fraud by APDCL. Why I am saying so, my lord? My lord will kindly come to page number 97. Page 97. This is the letter of award. Please come to my lord, paragraph 2BI. So before that, B. In terms of RFS and PPA performance bank guarantee of so-and-so amount, Lordship may kindly skip that. The performance security shall be furnished in the form of 3 bank guarantee as mentioned below in favor of the Chief General Manager, Commercial, APDCL payable at Guwahati as per format provided in Schedule 3 of the PPA, and having validity up to 22 months from the date of signing of the PPA. My lord, 15 to 21 is the date of signing of PPA. So as per the letter of award, the bank guarantee should be valid for a period of 22 months, commencing from date of signing of the PPA, which is 15 to 21. So therefore, my lord, all the PPAs should be of 22 months. My lord, I am the customer. There is a requirement envisaged by the letter of award. So I have instructed my bank, give him a PPA for 22 months. Now that is what has been done. My learned friend has read only clause 4.3. Why my learned friend did not read 4.3? Please come to page 102, my lord. My lord, you can't read a particular passage in a bank guarantee and try to call out a meaning. You have to read as a whole and give a meaning to it, even on merits. 3. These guarantees shall be irrevocable and shall remain in full force and effect for a period of 22 months from the date of signing of PPA unless discharge released earlier by APDCL in accordance with the provisions of the agreement. The guarantor's liability in aggregate is limited to so and so. So are we not to give a meaning to this particular clause, my lord? My lord, I am a customer. There is a requirement of giving a bank guarantee. Letter of award emphasizes the requirement. It should be for 22 months. So from 15 to 21, it should that is the requirement. Why the bank will give it beyond that, my lord? End of the day, I am to pay. Bank has extended me the benefit, but it is the contractor who will pay the money. Then my lord will kindly come to the non-obstante part. Notwithstanding anything to the contrary contained herein, our liability under this guarantee shall not exceed 84 lakhs. These bank guarantees shall be valid up to 24/1/23. Now my lord will kindly come to 3. 3 has a definite connotation. It also has a meaning. If it is not even, assuming for the sake of argument, it's not a case of fraud. It was done behind me. I have no privity of contract as regards this document, my lord. This between bank and the APDCL. We are liable to pay guarantee amount only if we receive from you address a written claim or demand not later than 1 year from the said expiry. But Lord, it only recognizes the power of the contracting party to enforce it. But enforce it, you can go to civil court, file a civil suit, do something. But to the extent of, my lord, encashing or invoking it cannot be beyond the, my lord, the expiry date. It is something like a, my lord, negotiable instrument. A bearer check is valid for 3 months. Why does the bank, while giving loan, takes that blank check? Because if I put the date on the day of taking loan, my lord, the 3 months period will be over. They cannot invoke it. So therefore, my lord, the argument that this is the only clause which will govern the rights of the parties is not correct. You have to give a meaning as a whole. Perhaps it recognizes the right of the, my lord, APDCL to recover it. That is, my lord, you do it in accordance with law. But insofar as that instrument of bank guarantee is concerned, if you want to invoke it, it has to be with the before the expiry date. There can be no two opinion about that, my lord. Here, perhaps, subject to what your lordships may say, my lord, perhaps this 1 year they may recover it if it is otherwise permissible in accordance with law. But as far as invocation part is concerned, there cannot be any two opinion that it has to be done within the validity period. Otherwise, my lordship will kindly test it from another angle. Why does sometimes what happens, my lord, there is delay in giving the letter of award. Why does the employer always says, extend your bank guarantee? Why? This is the reason. Because it is always bound by an outer time limit. It happens, my lord. Sometimes during the course of execution of a contract, supposing, my lord, the period of execution is also delayed, then, my lord, the bank guarantee needs to be extended by the contractor. Otherwise, my lord, his bid will become defective. So, therefore, my humble submission is, my lord, Learned Single Judge has only taken a tentative view. Final view has not been taken. My lord, the law which the Honorable Supreme Court has laid down, that bank guarantee can be invoked only in case of two exceptions, fraud and irretrievable damage. That is a view which Honorable Supreme Court has taken after seeing the law, after when a finality is given to the, the transaction, here the finality has not come to it. It is yet to achieve, my lord. Therefore, in my humble submission, at best, my lord, the matter can be expedited. The hearing can be expedited. And end of the day, is it not a question of law? And my learned friend is referring to, my lord, Cochin International Airport. That is in the context of a contract, my lord. Here we have raised a question of law. And my lord, is the learned single judge powerless? Even if party does not plead a point, if an illegality comes to the notice of the 226 court, is the 226 court like a civil suit will decline to refuse, entertain a plea, my lord? End of the day, this aspect, my lord, let me, to be honest to the honorable learned single judge, I think we should have taken a plea that here is a case of fraud, which he did not. Yesterday evening, my lord, while preparing the case, my lord, this thought came to my mind. Why not it's a case of fraud? Having incorporated this clause. In fact, my lord, when we filed the petition, this was not playing in our mind. Yesterday, I felt, my lord. Anyway, my lord, before the learned single judge, we may file an additional affidavit to take that plea. Therefore, my lord, I don't think it's a case where lordships will, interfere with the exercise of discretion by the learned single judge. That too only at the interim stage. And the view doesn't appear to be palpably wrong, that it calls for any correction by lordship's power under writ appellate court. And my lord, we have already informed the bank that since the validity has expired, therefore you don't invoke it. That intimation we have given. Yes, my lord.
This is true.
Yes,
That the point that must be taken is practically a legal point.
yes.
You may have made out a legal point before because there is no pleading to that.
No, there is no case. That's why I say.
Two, that format that was submitted, it was submitted by. And that format is there in the tender condition, tender documents. Now, the only thing which is public, my lord, is that whether we should in the appellate court enter into it and
No.
decide the issue,
Or
we request the honorable single judge
to expedite the hearing.
that you require you to file an application, leave application, and we request the honorable single judge to take up this point.
On 11th itself.
On 11th or on a day, because they have time only till 24/1.
Yes.
Because this condition is there in practically in all contracts nowadays.
Yes.
That 1 year period, and maybe you cannot take that plea that it's a fraud because you had submitted.
Exactly. I was about to say that.
But we
No,
don't want to
my
enter
lord.
into it.
No. Why I am saying fraud? For the simple reason, I have got no privity of contract as regards this bank guarantee.
Bank.
Where I have informed the bank, my lord, I am not a party to this.
None of that.
But then we don't want to enter into that.
Yes.
Now, today,
Huh.
because there's a legal point,
Huh.
honorable single judge has drawn it.
Hmm.
Let that matter be done, only your problem is that you will have to file a further application.
Yes.
You file it, take these points.
Yes.
Request the honorable single judge to expedite the matter.
Because learned single judge has not decided the issue.
Our problem, as has rightly fallen from your lordships, our problem is that 24th of January, 24, we'll be left with no option.
No, 11 December is the date.
Now they're
My lord, it's a fine that the request will go to the honorable single judge within a week or two, you file an application.
Yes.
And the
seeking leave that we should be allowed to invoke.
liberty is already, so it
Hmm.
will not be proper for us now because there is not a final conclusion.
I appreciate.
So there's no final conclusion. That's
Hmm.
what-
Yes.
Right, you have a case. And he has submitted basing on your format, but these have to be,
Adjudicated.
these have to be tested. So kindly do that.
Yes,
So that, and my lord will be directing that you can file an application within a week.
we can, yes, we'll file it within a week.
Then make a prayer by 11, even before the event.
Yes.
We want the first one. You want to do this?
Let's see if something is.
Mal, mal, mal.
Sir. I used to bring it. By kidney. Representing the Assam Power Distribution Company Limited. Also the second or the senior advocate. Assisted by Sanjay Vattal, advocate. This intra-company has been instituted by the appellant. By the Assam Power Distribution Company Limited. I mean, again, it is. An order dated, interim order dated 8/11/2023. Passed by the London Civil Judge in WPC number 6446 of 2023. By which a conditional restraint was imposed upon the agency from invoking the line guarantees involved. The petition supplement was instituted by the respondent number 1 today. Raising a grievance with regard to the steps taken by UTC for invoking the bank guarantee. During the course of hearing, a legal point if to the court to the extent that to the effect that as to whether a bank guarantee which stood expired can still be encashed without extending the validity period of the same. Basing on a clause incorporated that the bank is bound to pay the guarantee amount in an extended period of 1 year from the expiry. The Honorable Single Judge in his order dated 8/11/2022 held as follows.
127.
But I chose it, senior advocate, appearing for APDC. Has contested the conclusions arrived at by the university. And by relying on the finding recorded in the order dated 8/11/2022 that there was no fraud or irreparable damage to the parties involved in the location of the bank and comma had content the legal point quoted in the order is clearly not sustained. Per contract, Secretary Chaudhary Senior Advocate has contended that he views as recording in the order dated 8/11/20 by the Lawrence is fully tentative in nature and the same is not a final order. And according submits that the present fee be not be proceeded with and the issue be left open for a decision by the honorable by the Lawrence. So we have considered the sufficient advanced, right, and by the parties to the proceeding, and also fails the materials on that. And we are of the view that given the tax situation involved, the issue, the legal issue, which has been formulated by the Honorable Single Judge, is to be first adjudicated in the writ proceedings before in the writ proceedings and not in the present proceedings. We have noticed that the parties have not addressed the Honorable Clarence Judge on the issue raised. And the Honorable Single Judge had granted the liberty to seek leave of the court before encashing the time. Accordingly, we are of the view that this writ appeal is to be closed and the parties and the APDs be required to approach the Lawrence Single Judge by way of an appropriate application in terms of the order dated 8/11/2023. In the event of such application, we request the Lawrence Single Judge to request the report to expeditiously consider the same and arrive at the conclusion with the legal issue raised in view of the time that the time guarantee, the outside date for encashment of the bank guarantees all are the same.
No, madam. In two, it is 24/1, in one, it is 26/1.
Outside date for encashment of the bank guarantees are 24/1/2023 and 26/1/2024.
It will be 24.
24.
24.
View of the happy stands disposed of in terms of the. I think this will suffice.
Yes, I think, my lord, any view if your lordship is expressed only for the
Any view. Expressed by this would not be binding.
deeply obliged.
Giving the consideration of the petition as well as the application as may be filed by the.
Deeply.
Obliged.
Take time. Next is,
5, 6, 7 and 8 of daily leave order.
Please, my lords, a concrete policy regarding the vending zones was to be placed by the GMC authorities.
They were supposed to give us the final picture.
Yes, my lord.
Mr. Naik. P9. Mr. Kumar, Mr. P9. They have not finalized the.
have you finalized the vending,
We have not been informed yet, my lord, so
yes. Okay.
He's on Lex Lordship. Can it be taken after some time?
much obliged. My lord.
Nine.
Well, may I kindly page the last order, my lord. They were supposed to take decision on payment of our pension, my lord.
Speaking out of it.
So, and is it really-
I'm appearing for the General Administration Department. As per the last order, we have Lordship written to the Deputy Commissioner, Nagaon, since the Deputy Commissioner is the pension sanctioning authority. Your Lord. Therefore, now Lordship, the PC Nagaon will.
No, that was done on 3/10/23. That was a submission on 3/10/23.
Lordship.
That the order by the reforms training pension public grievances department is passed.
Right.
Now the decision would be taken,
Yes.
but the decision has
Yes.
not been taken.
Lordship, I need some time to take the instruction regarding the decision from the district commissioner, Lordship.
Deputy Commissioner.
Is a party here.
Yes, Lordship.
How much time do you require?
Lordship, 2 weeks, Lordship.
Do it, pension matters.
Lordship.
There's a pension. Third, Mr.
RS Mishra, my lord.
R.S. Mishra, let me counsel for the applicant. Stop. Mr. Fukan, standing counsel GAT supports. That the department has written to the district commissioner.
Deputy Commissioner.
Deputy.
Nagaon.
Now it is district
Now it's
commissioner.
district commissioner.
Deputy commissioner.
District commissioner,
Nagaon.
No go.
now go.
Respond number 3.
Stating what?
Regarding lordship, pension of the petitioner lordship.
Regarding whether releasing the pension. Take necessary steps for releasing the pensionary benefits.
Yes.
Actually, he was retired from service from as a supervisory assistant, but he
No, no,
was
no.
acting as a
What did you write? You
Right.
wrote to the deputy
Yes,
commissioner.
Your
isn't
Lordship,
it?
we wrote, Your Lordship, that hence in view of the above direction of the Honorable High Court and the order passed by the Pension and Public Grievances Department.
Oh.
You are requested to take necessary steps for releasing the pensionary benefits in respect of Shri
Okay.
Krishna.
To take necessary steps for releasing the pensioner benefits in respect of the applicant. Stop.
As per clause.
As per clause 4 of the OM dated 12/7/2007. MS Alvar,
RB Bora.
RB Bora, Learned Standing Counsel,
Here I am as a junior government
Well,
advocate Assam.
Junior Governor Advocate Assam. Press for some time to enable her to receive instructions. As to what decision the district commissioner Lagom has taken. So, praise allowed. How much time will require?
2 weeks lordship.
Make it early. Try to come with a decision. It's a pension matter.
Yes.
You don't want to keep it pending.
So they have already directed him to do it, so he should act on it.
30.
No.
Fourteen, 15, and 16 hearing.
Worship, the issue in this matter, I am told by the counsel for the industries department is pending for adjudication for the Honorable Supreme Court.
No finality has.
No,
The
But-
principal amount has been paid. There is a submission of Mr.
Yes.
Tony here, so the interest has not been paid. And that is pending.
otherwise it's a, there is a covered judgment of a division bench of this court.
But
That is before the Supreme Court.
no decision has come.
No.
Mr. R.K. Jeff Chowdhury. Leonard. Deputy Solicitor General submits that the issue involved in the present division is pending before the Honorable Supreme Court.
Worship.
When do you want?
Let it be a longish date, Worship.
Is the matter? In
After 4 weeks,
January?
Yes.
January would be better. Last. Yeah. On 25th of January. 2024.
Lordship item 14 to 16.
He has already met with the Supreme, as the. Supreme
Matter is
Court-
pending in Supreme
then
Court,
that-
Lordship.
That's what,
So matter may come up in month of February, Lordship.
February, January 25th, we have fixed.
Much obliged.
17.
May please the lordship. But the matter relates to the appointment of LPG distributorship. The applicant before your lordship was selected for the appointment. The unsuccessful candidate filed a writ petition on the ground that I had no land for the showroom. But owning means in terms and conditions that either owned by himself or it is a lease. I had taken lease from a certain person. The point was that my lessor was not the absolute owner. He was a co-owner. And on that ground, it was set aside. Your Lordship, please to see clause 3 of the advertisement, page 34, 39.
Response number 1, 2, and 3, madam. 3 and 4, madam.
Huh?
One is the
BPCL.
private respondent.
No, madam.
Private respondent is, my lord, the writ petitioner is,
I am for 2, 3, 4, and 5, madam. Mr. TJ Mohanto is there.
Who's appealing for the writ petitioner?
T.J. Mohanto was there, possibly. Huh?
He's coming.
ইফালে থাকে না, ইফালে থাকে না। কি নকয় কি? আহিব। Page 34, 39, your lordship, please to see, of the appeal memo.
Where's TG Manda?
He said he is coming.
He is coming, madam.
Is he ready?
You are for the private response. Yes.
Writ petitioner, writ petition.
Ready?
I'm waiting for that to inform Mr. Morgan.
That's the reason why we don't want to keep it part-heard.
Can keep it.
In time order also, madam. We are supplying, madam.
This bench is sitting only
for
for
2 days.
2 days.
Oh. Oh, oh.
That's the problem.
It's a small matter, madam. Can take the disposal.
Let it be on next week.
But there's a intent order for
Can
both
I
sides, madam.
just ask one thing?
Yes.
You have taken the plea of section 44 of the transfer property. Was this property land demarcated? at the time?
Subsequently demarcated.
Subsequent.
Subsequently.
On the date of
On the date of the application, he was a co-sharer.
it's co-sharing.
He was a
So
co-sharer.
that is why the.
That is that, that
That
is
is the reason.
In the plane itself, my lord.
On the date of the.
That's not hearing. Just want to-
You want a date? Okay, how Mr.
Because if
Rishi
it's
does.
partner, then it will be difficult. I'll not be.
No,
able
no,
to take
Senior
this.
counsel assisted by Mr.
It's Ricky.
J.S. Chilikia.
Counsel for the appeal. On request made on behalf of Mr. T.G. Mandan, then the senior counsel. Appealing for the respond number 1 oblique writ petitioner.
Respond number one.
After 1 week.
At the 5 o'clock.
Huh?
Yes, no, 5 o'clock.
Yes. कितने डेट कितने कितने दिन को
Madam, fix a date, madam. Madam, fix a date, madam.
You want a date fix?
Yes,
Yes.
madam. There's a intent order of writing.
28.
oh, oh. Yes, but
20 enter, sir. 19 enter, sir.
no, no. Yeah. Yes.
I have difficulty.
Yes, difficulty. बाप रे कितने वो
28.
28.
20,
May it please your lordships.
Yes.
My lord, in this case, my lord, appellant is aggrieved by the order dated 22nd March 2018, my lord, passed by this honorable single judge, dismissing his prayer for disability pension. Case 77, my lord.
Yes.
My lord, cases like that, my lord, appellant was appointed in the year 1981, my lord. In the year 1992, when he was in duty, my lord, he met with an accident and got serious injury, my lord. And because of that injury, my lord, he was operated and his spleen was removed, my lord. And he was placed low medical category. And that low medical category, my lord, it was approved, my lord, in the year 1995. Then, my lord, he was forced to sign the medical board's decision by saying that he will be released from service. And petitioner was not agreed to that, my lord, as because he has spent 17 years of service, my lord. He was a healthy person, my lord. Suddenly that accident took place and my lord, he was supposed to release from service, my lord. So he, my lord, he refused to sign on medical document, my lord, and he wanted some other duty, my lord, light engagement, my lord, but that was not given, my lord. And the medical officer, my lord, mercilessly beaten him, my lord. And out of fear, my lord, he did not, my lord, sign on the medical document, and he filed an application for compulsory retirement. And immediately, my lord, department has approved that. And my lord, he is getting compulsory pension, my lord, from the year 1999. But because, my lord, he was, my lord, disabled because of government duty, my lord, he is entitled for disability pension also, my lord. That is my prayer.
But then you refuse to be invalidated, isn't it?
My lord, that is, my lord,
You refuse to have medical examination.
only, my lord, that portion, because, my lord, I was beaten by the medical officer. They said, you sign on this paper, you will be released from service. That fear, my lord, I thought that if I sign on this document, my lord, I will be immediately released. And that fact they have admitted in their affidavit in opposition that you will be released from service. That's why, my lord, I was beaten by the officer also. You sign on these documents, my lord. Then out of fear, my lord, I did not sign. And immediately, my lord, they forced, my lord. And finding no way out, my lord, I filed an application for compulsory retirement and they immediately approved. In the year 1999, I am getting that pension, my lord. But as because my injury that is on government duty, I am entitled also disability pension also. That is my case.
And how do you explain your delay?
Delay, my lord. First, I initially, my lord, filed one case in Delhi High Court, my lord.
That was dismissed.
Because of territorial jurisdiction. Thereafter, I filed case here also. That was also for some documents which the petitioner could not annex.
You filed after 11 years.
That is also, my lord. And because, my lord, I filed representation, I filed legal notice, all these things, my lord. But I thought that as because this is a pension matter, my lord, I may get, my lord. And as per rule also, I am entitled for disability pension, my lord. And there is some notification of the department, central government employee also.
See, there are two issues here.
My lord.
You refuse to have your medical checkup, medical examination.
Only, my lord, last.
Then you took compulsory retirement.
Out of.
All right. Then the other question is the issue of approaching the court late. So this.
I filed representation also, my lord, and I thought that it is a pension matter, my lord, delay will not come.
And in the Delhi High Court, you have not paid for disability pension.
That was a regular pension.
It was a regular pension.
That is, my lord, out of my ignorance of knowledge, my lord.
How?
And my lord, advocate also did not. Look, kindly see this poem.
What poem?
Please give me disability pension, my lord. And as per rule also, extraordinary pension rule, my lord, I am entitled for disability pension.
is pointing that to be eligible for disability pension, you will have to be medically examined. And that medical examination should have been in sometime in 99. Today, you can't be medically examined. Without medical examination report, how can there be a disability pension? Just answer on that.
My lord, medical, I was placed low medical category. Medically, my lord, I was examined. Only, my lord, percentage was not final medical board, my percentage of disability. But I was
The
placed
issue is
low.
you refuse to have a medical examination. And today you're claiming for medical disability pension. How do you get your disability pension? After having a medical examination?
My lord, at that time, my lord, I was medically examined, my lord, and I was placed low medical category because of this, my lord. All the documents were there in, my lord, in the department. All facts remain there, my lord. Actually, because of my lord, out of fear, I did not agree because the officer beaten me, my lord, as I refused to. I thought that if as soon as I sign on the document, my service will go, my lord. That was my.
How do we deal? Which? Yeah. Try to get some decisions. Otherwise, you have no case as of today. Let us
Worship,
give you some time.
My
Worship, it's
my lord.
too late in the day because now her client cannot be medically examined.
My
She can take a chance. She can take a chance.
Medical operation itself
Yes, my lord.
is sufficient.
My lord.
Satisfies rule 170. The disability pension.
My lord.
We can get some material decisions on that.
My lord.
Then maybe a case.
My-
Otherwise, it will be difficult.
The 173 says you have to be assessed 20% or above.
Yes, my lord.
Now you have not been assessed. How can you assess today?
My lord.
Find out some.
My lord.
This much is also enough. So that.
My lord.
Can help. Otherwise,
My lord.
Your good name?
Yes, Bora.
Request made by Bora, then it comes for that. This after
After 3 weeks.
3 weeks.
Yes.
Twenty-one.
May I please your lordship. Lordship, in this matter, I shall have to file an application for implement, my lord, of the
That time that was already granted to you
My lord,
in the month of August.
My lord, I could not collect the name of the liquidator, my lord. Entire company is on liquidation. Kachar paper project, my lord.
There are. It's spending.
Lordship.
Some of it. But this has been pending otherwise.
Lordship. 2 weeks time, my lord.
Okay.
In the meantime, I will
Your
file
good
it.
time?
TU Laskar, my lord.
May not. Oh, okay. Can request Mr. T. U. Laskar Leonard, Council for the Appellate States. Appraised for 2 weeks' time. For implement of the official liquidity
Official liquidity.
as party respondent in the present. Praise alert. List up to 2 weeks. If no application is made. If the implement application is not made within the prescribed period. This writ appeal shall proceed and.
Obliged.
22 to 27.
May it please the Lordship. Lordship, this matter pertains to the question of grant of grace marks in the TET examination. Lordship probably appeared for some of the petitioners in this. Lordship.
Okay, release this case. Before any other bench without one of us.
Yes, sir.
Justice, you can.
Much obliged.
That is up to 27.
Twenty-eight.
Item 28 is a.
Your Lordship, Senior Advocate Bedilas has to go out of the court for some personal urgency. Kindly pass over the matter if possible.
For the day or for time?
For timely, actually.
This list is about to complete, my lord. It's item number
Kindly
8.
list it Monday.
Part NG Kataniel and the Standing Council, Elementary Education Department.
Yes, madam.
For the applicants. On request, Madam, behalf of Mr. B.T. Das and the City Council for the respondent.
Yes, madam.
List after
Monday.
Yeah,
Any date in next week, madam?
22nd.
Obliged, lordship.
Item 5 to 8 order.
Yes.
Lordship,
yes.
please on legs, Lordship, pass over for the day, Lordship, on behalf of Pinayak.
Why don't you take that instruction? What has happened?
Can you get the instructions, Bola? We'll wait for some time.
No.
Get the if there's any instruction
I just-
with regard to the town vending committee.
Commissioner.
I'm sorry. Lordship, so far as item number 5 is concerned, Lordship, on last date, Lordship, and the court passed an order directing us to give a time frame for constituting the time.
No, you said that the process for constitution of the
Yes,
town
that,
bond
that,
is
that
in
has,
an
that
advanced
has been
stage.
constituted, Lord. Notification I have not yet received, Lordship, but they have informed me over phone that that has been constituted and it will be come out on the next date, Lordship, I will be able to place it. It has been constituted. Lord.
After that, what happens?
Thereafter, Lordship, new zones will be marked. Lordship.
Demarcated.
Yes. Lordship. Already for that also Lordship process is going on. And the concerned ward commissioners, they have already given their choices, Lordship. Some of the commissioners.
So you want some time?
Ultimately, it will be placed before the committee, Lordship, and committee will finalize. But one thing only I would like to place, Lordship. Yesterday, I talked to the counsel of the petitioner also, Lordship. Today, he is not present. Lordship, in that petition, Lordship, in the first petition, his basic grievance is that the footpaths were encroached by the street vendor. Accordingly, the elderly persons are getting it difficult to use the footpath. That is the basic issue. And in that case, Lordship, we have filed our affidavit also. And there we have mentioned some of the steps that has been taken by the GMC authority, Lordship, and what are our limitations, Lordship. Lordship, he was agreeable to me that Lordship may pass certain direction, Lordship, and that petition may be closed, Lordship. But today he is not present. And
then you take instructions with regard to the process of
Other matters.
demarcation of zones.
Yes, demarcation of zones are basically related to the other petitions.
That also bearing that.
Yes.
Since it's all another.
Lordship, on the next date, Lordship, I will place that, Lordship.
Mr. B. Nayak, Standing Council GMPA, submits that the downwinding committee has already been constituted. Stop. He also further submits that the process of demarcation of wards is in process.
Demarcation
Demarcation of vending zones is in process, and therefore prays for some time to enable him to produce the notification constituting the town vending committee, as well as the report of the as well as the process.
Yes,
for
status of the process.
demarcation, status of the process for demarcation of vending zones. So how much time?
Lordship will take up this one after 2 weeks.
This after 2 weeks. Okay. What is this?
Obliged, ma'am.